authority.
Please, your lordships, I am here with Mr. Appellants, Mr. Holmes, Ms. Patel, Perry appear for the I'm not from KC and Mr. Office. Housekeeping, your lordship, 3 core bundle, 1 supplementary, and 2 parties. The Home Office has an extra bundle, which is 8, because it contains material that was not before the proposed to take up. Now, object to the court the Home Office material. You can see the relevant.
Well, whatever qualification you want to look at it.
I'm obliged. So, subject to introduce our briefly, or again very briefly, it's agreed each of the 2 appeal in turn. This is an important case. Concerns the of his power under 134 Act to write an agreement produced by an otherwise lawful procurement process. Now, such procurement process does not such agreements immunity competition law scrutiny, but it is rare because the procurement process the conditions in the terms operation contract. In this case, we will to look at the of competition at the ends of its life. Procurement ensure terms of the by agreement competitive and prospect of a replacement by a further size produces 2 constraints. And by our 1, we saw the CMA and the tribunal failed to the extent to which the product of the new network parties the extent of the existing Airwave contract. More striking, when the in defining accepted that such constraints could exist such Airwave were in the market. By our ground, we submitted that they acted irrationally when they decided to give Airwave's assets a 0 value after 2019. They may found in the process that in a functioning market, the PFI agreement should be provided for the of assets to at 0 in around 2019 and 2020. But there's no finding that the process that the PFI was not well functioning, and nor did it make express or failure of the PFI agreement to transfer of the asset value constant and adverse effect. And we say absent findings, the PFI agreement be taken to reflect a well market, and it may for the transfer at the end of the contract. It provided that if the government take possession of the Airwave assets, the government could at, and I quote, market not value. And as I will the court, the tribunal ought to have found that the decisions of value at 0 were irrational. And my lords, appreciate that as back from this case, it may be to change the bargain so as to relieve the payer of the burden should not be lightly. The implications for this are very serious. They continue to bear the burdens under the contract to 2029, but their revenue will be reduced very significantly below the level agreed by His Majesty's. If I may move on then to, there is no real dispute with the legal standard. And if there's content, I'll go to the judgment of the tribunal. Some relevant points before moving on themselves. And so I'll take up the judgment behind tab 7. And I'll do first test to be applied by the, and second standard to which the CMA is 04p of core bundle behind tab. And the relevant section of the 4 sub 1 provide a shall on a reference to whether any feature or features each relevant market restricts, distorts competition in connection with the supply of any goods in the UK. And 17, section 134 sub is an adverse competition, any feature or features market restricts or distorts in connection with supply of any goods or services. Okay. Is on prevention or distortion of competition. To the judicial review, the tribunal using Tesco paragraph 26 on page 6. If I may pick up paragraphs of Tesco, they're relevant particular to ground, and I'll be on the second 77 here of a decision to take account of consideration. His decision is most frequently relied on to review, sometimes considered under the label of irrational, and perhaps more in case treated as a ground the validity decision, and the concept of taking account of consideration reflect the fact that the review is in general a process rather than a merit, nor will it already quash every perspective which it is at a relevant account. The court will normally whether the factor could have been material decision, though strict is too insignificant to affect a decision, and its validity may be. And particular relevance to my ground, the reasons the rationality stand with Wells and the tribunal, paragraph 28, the page on page 7. The judge there, Wednesbury, 22, a more new, modern public law is to test the ultimate conclusion against the evidence before, and to ask whether the conclusion, and with due deference to the panel's expertise be safely on the basis of that, particularly where anxious scrutiny is applied. 3. The approach is just another way of Green's dicta, but it is, in my view, to approach the more practical and terms, lines. Conclusion follow or evidential gap, deep in reasoning, fails to justify the conclusion. That's all I put at the rationality. The court will, that on the subject we appear to be agreed. To the extent it may use for some kind of margin in this matter, and it's not clear that refer to his own judgment in Sorelli here at this point. It's so familiar to you, up and I may says about the standard. But with that, the law, my lords, to turn to 1. And for this, the court to take up itself, the CMA's for some setting. The summary in the bundle tab 9, 19. And here summarizes the motivation. 9. We have identified the market as the of communication services and ancillary services. We refer in this report as supply of communication network services 50. We've considered how competition can occur in the market, and this is important. Building a integrated contract required meant the supplier based to meet the emergency needs on term contract. Under the supplier could large upfront to build a network and the chance to earn a rate of return over contracts. Competitive on suppliers and therefore, because it's an integrated network with through competition for the market. It's not a competitors in the market. Competition occurs. It can then contracts are first and they expire, or specifically of when a network or a retained existing network is competing. And this is a situation where only a single competition place is the whole market. The CMA summarized here these competitors long-term contracts and later they're about to expire and replace the network the supplier. And then page 193, here are implications of the place in the year 2000 that emerged from it. And this is important because rely on the term the price of our ground. In our assessment, the paragraph of the PFI agreement, the Airwave network resulted of process that we might expect competition in the market. The original period PFI agreement had the opportunity to run an open competition for a supplier to agree terms trained of the provision of, and in such a competition, the supplier would reasonably have to set the price level that would enable its costs to earn reasonably for the period of the contract.
challenge that proposition element in paragraph 14 and also in paragraph that the assumption in the bid, in the tender process, the contract seek to set a price with its
Indeed.
its cost over the.
That would be the expectation in an agreement. I mean, and of course, this is the answer. But of course, my lord will have other aspects which the address as well. Range of factors in any PFI. This one, risk for both are also the overall package in the contract.
You're aware of that when you enter. So set your rate of return in reference to the risk you might expect to bear, suffer from, or benefit over the course.
Indeed, but the degree of certainty parties have as risks will not.
Yes.
Is a different matter. There are risks inherent in. There are many unknowns going into this agreement. Yes. They have to manage that risk. Those in negotiating the PFI agreement.
And so, assess,
yes,
evaluate, pick a figure.
Indeed. So the two obvious ones, a risk that they end up spending more to build an assessing.
Yes.
Which indeed actually happens, as we'll see. Yeah. The Home Office network will not when the agreement expires. Those are which need to be identified by both at the time of the agreement. And the PFI resulted from the original exercise. Next term ending in 2019, it provides designed to recoup investment for the possibility of estimated rate of return period, but not beyond it. It contains sought to deal with the contract transfer of an office or to a third. In terms relating contemplating its extent. The revenue, therefore, really the type of term we might expect in a well-functioning market in 2019, but yet they were not all fully effective in their objectives. This is not the case, says post-2019, paragraph 16. Position now, the original period of the period ended is material. Investment in the terms that is provided after reflecting a very unconstrained position as part and the result of a competitive process. And CMA found 4 in its competitive, to which I will return. Paragraph 17, instead of being set through the process, says the CMA prices are established or maintained at significant variation levels in bilateral negotiation between Airwave and the Home relating to the PFI agreement. In those negotiations, as the CMA, the Home has no credible option of its choice by or supply. That may be true in a sense. We ask, what about the of the of that there would be an alternative, albeit within a period of time? And what was the, if any, that long, what we dynamic competition? That critical question not addressed in the CMA's competition. That is taken into account very relevant consideration, to which I will return. It is addressed in section 3, market definition. You've seen from the skeletons argued May. The procurement exercise were a complete answer. Need to examine the competition, Airwave, and during the PFI agreements, including its extensions, agreed that after 2015, there was scope between Airwave and SN, we placed them in the same market. You can see in the same bundle, same decision, but now we're going on 243. Excuse me, 242 is the section to sue, and then 53, paragraph 3 sets up.
Sorry to rise, but I think our understanding that there was a stream of this which isn't happening. I don't know whether it was misinformation.
I thought we'd approved a script.
I don't know. I've just been.
I thought I approved it last week.
So,
Support on this. This is last.
I'm told the same, but I don't know.
Live stream.
I can't assist further now anymore. I'm told.
Who can we ask?
They're reporting.
Only the reporting. To go on when we take a note of it, we just have to. There is a 2-minute silence at 11 o'clock anyway, so we'll have to. So, do you want to stop?
Sorry to have disturbed Canelli in full flow.
Yeah, issues as much as people want to watch. Well, watch. The trouble is, one just things recommended if sound's not working, how quickly they can work.
In the court 8.37, and this really is just to set up the importance of the point of dynamic competition. We say was CMA and the critical dealing with constraints and second, and we see it in 3.36. Part of that paragraph illuminate bargaining by firms outside and perception of future market circumstances, such as potential, the uncertainty is expression, potential future opportunities, third party and third market circumstances at the time of original contractual negotiation. The PFI itself doesn't give you the full. You have to ask in extensions at the end the bargaining power of the party, and that is affected by their future outside options, their future contract. Court could go on, please. Page 26. We see just so you see the heading is market definition. 263, we see the our assessment, and the court then to paragraph 8.75. The time is, and I begin over page sentence. View is that there is for competitive actions between ESN and the Airwave. In particular, ESN is still not available term. Central incentive for buyers to develop ESN in a timely manner comes from winning from the Airwave. We also prospect ESN being developed as a replacement for the Airwave could, in principle, affect the objectives of Airwave Solutions to maintain aspects of its offer with a view to delay transferring to 376 competition, competitive efforts terms that result in being won or lost term. For example, this might include prices offered in competition, referring to competitive efforts winning customers after the competition is made. Investments made today in winning new customers years in the future. Both dynamic and static competition in this market. A supplier may face constraints when competing and dynamically, and considering the appropriate market we side and subsidy through both. 3.77 substitutability short run from in the longer term. In the short run, products in their existing portfolios, firms may compete in their products. In this competition and supply, LMR services for public safety, that's us over the longer term. Longer term competition between Airwave and ESN within this category term competition because it involves the efforts and investments by ESN in new offers, which would serve as a for LMR services, real Airwave Solutions in a timely use demand sides. It can also by Airwave customers and prevent delay to ESN. The question for the second is, did the effect of ESN constrain Airwave to make effort for customers and delivering to a more question because the CMA found only scope competition was a term constraint. We see that on page 266, 3.8. Right, halfway down, the CMA said, because Airwave Solutions only demand side is competition, sends key suppliers developing a new solution. We note that in the and in particular the development of ESN, there's no scope for demand substitution between network and ESN. A customer associating with it can't realistically see a deal to walk away from the switch. ESN is now an option, so there's no competition. While market take account of short competition, focus on term is appropriate. And then this lack of substitution into account in our where see section of they say section 4 of substitution. They don't say that longer term will be taken for, and when we come to you'll see what May said about that. But what's is that the CMA, from market definition, saying longer term competition that will take place at a point in the where it's entered service. It's dynamic competition still in development. It's the process of ESN that provides a constraint. And that's how the CMA find that ESN are in the same long before ESN is actually in place. Now, found, and the CMA that this section containing that actually just could have a, and that we say to follow, because to we had to look at the process of substitution. That is longer term dynamic. It had to reach a whether such a of substitution existed. Find the market found that it did. Its own guidance that substitutes competitive, and that's too obvious a proposition to take you to the guidance, but for your note, it's in the volume of authorities, page 1262, paragraph 2.5. But where that substitution is 2.5, prospect substitution exists. Prospect that placement stream, when that exists, it's dynamic large competition. The prospect of the provides the constraint. Now, even if was right, section 3 contains finding actual dynamic competition, whether it existed, to what extent.
Please, please. This is the control. Now invited to a 2 silence. The anniversary of our Mrs.
that even if in light there was no finding in of actual competition. Question, well, whether there dynamic longer term and to what extent that still falls in section 4 in the competitive assessment. But before we look at what the CMA say, I'd like to take your evidence that the CMA is the same. In particular, negotiations that took 2016 and 2017, the Airwave was in process. Because it's common is paid today. We're at 16 discount on the agreement price. If you will note, that's page 46. So it's also that the price is paid in 2018 and 2022 reflected an discount on the 2016 was agreed in 2018. That paragraph 4. The negotiation 16 and in particular 18, because they get to show us the CMA to test whether there was long competition or not.
Once we start doing, aren't we going as of judicial?
My lord, because try to show else if the of the CMA that will for rationally connected force basis judicial review, and in ground, the CMA is that long competition material consideration. It fails to in section 4 that judicial review. The reason why I need to show you is to address quality. To show this isn't a taken by us trials, a serious to be answered. So therefore both relevant and material. The competitive assessment has to undertake in section. On that point, we go back to the CMA section 2 of that. And the picture we get from the section is that ES was on the radar for some time. But my core one is that the prospect ES was producing a CMA called long competition. See the story on 2.9 of the bond, paragraph 2.7. Early as 2011, and that's the services communications with the objective of fixing the airwave network. The conducted extended market engagement 11 and 2014 concerning selection, and in paragraph 2.7 the idea was that new replacement use a commercial network basis for the replacement. Following this program, and this is ESN contracts public procurement process took place. Page 232, paragraph 2.8. This ESN into so as we say use dynamic competition. 2.82, there was to be a transition during which users would move from ESN. Timetable start in 2019 and the end of 2019. The plan had originally to allow for a transition due to 2.5 due to the cost network. The office is concerned about the wave. They want a transition period to bring on ES even more by 2029. And you go on to page 285 for the chronology. In 20, Motorola and acquired solutions query, and then negotiate with the home. And over the page, date product of that negotiation. The heads of terms dates were aligned across all the emergency solutions. Shutdown date of 31st 2019. That involved a extension of some of the contracts, all up to a common NS or national shutdown, and Motorola discount that overall deal. And we see in our reply. Take you to are in the decision more clearly in the reply. Reply is in the agreement bundle. Tab 8. Page 219. Text. This the table in the part of the reply, the bargaining Home Office in 2018. You see that in the heading, top of the page, and paragraph 21 that Home Office being in a weak position, offered these discounts, and said asked the court to look at the discount offers. These are all confidential. So I need to
necessarily follow as a logic. The Home Office being in a bargaining would not. It's all about the discounts, isn't it?
Indeed, and yes, and the scale of discounts may only be in a separate position of the Home Office. It begs the question. This is because our JR point take into account. My submission is what we see here. Discounts because of dynamic competitive pressure, because it perceives the value of ESN. Precisely why in section CMA kind of longer term competition, the CMA section 3. Why, we ask, was it not analysed in the competitive analysis before?
You don't say necessarily the result of competition, you say it.
My point is that in section the CMA found the existence of dynamic competition. Even if I'm wrong about that.
That's a critical, or a critical question. What said against didn't find theoretical section, as it were, a sort of theoretical analysis, and it uses words like would be or maybe, and then section reality. That's
we say section 3 find the existence of competition, but may still had to in section 4 what existed and to what in order to avoid an competition.
Do you have to let's just reference, there are a number of paragraphs in your permission to appeal, you refer negotiating position. They don't certainly address the question of dynamic competition and said it's part and parcel of the process. The point against you is that they analyse those they consider to be relevant, which did dynamic competition didn't, to say, in fact, they should have, though they didn't. That's a question of fact.
I have to, my lord, I have to show that they positively failed longer term dynamic competition. I need to show you in section that when they consider competitive constraints, they looked at static. The fact that the immediately to when it in particular.
On the first, that in chapter theory, not practice, do you then you have to then show that they would have looked at dynamic chapter 4.
Yes.
And you say there was a factual basis in that to trigger that.
Argument, I think, has to start. You have to recognise that there are a number of types of valuation judicial review. There are which are taken into account, statutory framework. There are which are so must be taken, which the decision maker may take into account. The decision maker relevant is wrong in informing not relevant. And there are things which are relevant, which the maker mustn't take in. And you've got dynamic, the second box, so obvious that CMA must account rather than CMA would not take it.
I entirely what my lordship has said. That's the threshold that I have to cross. And I say it is that it had to account because the CMA its own analysis section acknowledged that these types of contract, static competition is very unlikely to roll the ESM. What matters is longer term competition. The prospect, even though it's not ready yet, the prospect exercises a constraint of Motorola in negotiating. And as we said, obviously required to do so. And just to go to my Lord's point about show this is material, this is a real thing, I take the court to what happened. The uncontested evidence before CMA, and we're still in. I wanted to show you the first that table.
Yeah.
You see in the first row that a discount agreed, and the core contract to a common end date 2019. So were agreed, but discount at the same time. More significant are the dollars in 2018. For 20 other factors in play, 18 refocus. Backdrop to the 2018 negotiations, common ground anticipated that the mobilization completed by November 20, and that the Airwave shut down by December 2. Notes decision paragraphs 9.5 to 2. Of course, there was a degree of uncertainty as to when the bargaining dynamic parties for both parties. But let's see how it affected, and we see this in the same. And as I figures are reflected, see that from the footnote. It's footnote 25 page of our reply. The paragraph with the figures relate. And if you look at the offer in the table, significance of the it's the asking the approximate discount as a percentage of charges. Row, you see this a significant or a long extension, and the length of the extension is the third column. And we say discount reflects the higher prospect of ESN being ready. Because as ESN, because over the longer period, there's a greater prospect of being ready, and therefore we offer more in view of term competitive constraint. And then if you look at the third row, we know the Home Office didn't want to commit a long period that Motorola did. Why did it not to commit it? Because presumably ESN would be ready. So that again, ESN is affecting the office's bargaining position. The office asked for a vote. Break and 18-month extension, and we see lower discount, a significant discount by Motorola for that. And then in the back end, the whole wanted an even shorter 3 years, presumably ESN ready sooner, and a lower by Airwave, but still you can discount.
Can you just help me what dynamic competition means? So ESN was, the question was as to time.
Yes.
Going to be extended until this hypothesis 29 stage, there would have to be of all the customers across to Airwave. Given that they were governments, they wouldn't have been that, would there?
No, indeed.
So competition around question time at which they try, as if competition make them decide to transfer.
No, but the conditions in play here, in the CMA failed to say certain as when it comes, but if ESN is coming better to in the government for a longer period, because there's a possibility ESN will be ready for the term. So Motorola is seeking, with the ESN in its mind, Motorola is seeking to take longer, but in doing so, it has the prices because no ESN may be rather than later, and that it's I made was obvious constraint negotiations between Motorola in 2018. Prospect to the ESN as approximate, Motorola's negotiation weakens because it knows it needs to offer in a period, elapse with a period.
I compare that with the 81, describes the sort of that they're looking at, which seeks to assume the customer with Airwave some money designed switches. Doesn't seem to be the area we're considering. Have no choice. They will to ESN because they're government.
That is the government being negotiated on behalf of, and so dynamic. The CMA user, no, the CMA's bearing in mind this is I am based in CMA's process was of the bar between Motorola and as a unitary body was negotiating. And looking back on the words, it begs why was Motorola at all? If the CMA found the Home Office of Ireland had no alternative writing power, no material, why to say full whack, no choice? The discounts vary depending on, among other things, the term, degree of certainty that we have as ESN became more profitable. And we see terms offer the prospect of ESN more likely. That now
competition. I understand that there's an attempt to create the competitive ESN in relation to the point at which it comes into force.
Yes. Yes. The concern is because there's uncertainty. When will ESN come into force? When will it switch? Can we get the government to stick longer, even if can we for a period? For obvious revenue, obviously with the discount to pay because of the assessment that all parties of when ESN.
So this is really about the point at which it is introduced.
It's competition which is driven prospect, uncertain of ESN switching.
So they're trying to put this point in time 10.
Not ESN. I mean, what Motorola, all Motorola.
Well, keeping Airwave until 2029.
Yes.
Thereby switching to ESN today.
If I made a mistake there, will correct me. But the principle, well, my submission, as you've described, that is good or bad. The status may be good or bad, but what we see term dynamic competition driven by the happening, all uncertainty. But let's see how the deals with this question. And could I ask you to go to the defence? Same supplemental bundle, same agreement. Have 6 and paragraph. You see the has taken these proceedings, and if I ask the court to the middle of that first subparagraph 1, sub 1, and CMA pleads the tender and PFI agreement constrained prices for the intended to cover ending 2019 passage. ESN procurement will constrain prices once ESN operational. In circumstances where it has been delayed and parties are outside the term of the PFI, there is no operative competitive. In the CMA's case, the prospect of ESN created no operative constraint when we were extensions. So according to the need to look at dynamic term competition. As I say, that begs why Motorola offering discounts in 20. But the CMA is nuanced. Could ask you to, it's in the core bundle, tab 4, core bundle, page 56. Page 59. Paragraph 2, we argue to supposed to address long I think 3 it says requirement for the CMA to frame this lateral negotiation, including in 28 terms of long substitute. So no need to look at long constraints only. A strange submission in view of what the CMA said itself about long-term substitute in section 3. Was the CMA required to identify for each potential constraint whether the constraint was static or nature, so no need to between static or dynamic. And then this ruled out the short-term competitive the CMA competition necessitated long-term constraint. We did, in fact, when we discussed for the term constraints, look at section 4 to see a plausible interpretation. And then paragraph 30 for a roadmap in the decision, a longer term the decision whether it is a constraint. There's a recording CMA. There's a reference to the judgment paragraphs 81 to 80 that the tribunal analysed investigations, finding the CMA was entitled to conclude ESN didn't constraint at any given its lack of rate. So we'll come to what that means. And that's it. We're referring to 81, actually 80 of the. If we could go to judgment, see those. They have with where in this longer term is addressed. That's page 1 core bundle. Please, bottom of paragraph to orientate ourselves. The bottom of page, bottom of paragraph 8, page 138. CMA says the question of what ES fact act as relations between the home is section 4. Then deals with 26 sections. This paragraph to see where is examined. The examination impact, if any, prospect end becoming and to identifying the issue, whether the Home Office has options, constraints applied in a well-functioning CMA. Not looking through the paragraph, reference to longer term, but we see this of 81 reason. This is about 4 on the page. For this, the Home Office was unable to move away from work because of service and the ES ready. That reference to static they couldn't just switch away completely. Does whether respect to ESN becoming exercised had any effect?
Why did you deal with that? Not the existence of provider in terms of pricing Airwave, its pricing in 2016 is a question considered by the CMA, and the CMA did not finding at the end of it.
Well, indeed, that begs the question. That's what the CMA, and it said that it didn't. Okay, decision then. CMA examined whether dynamic exercised any right, because the paragraph is that is a conclusion. It doesn't tell us if a examination to static. Obviously, one can't switch away immediately. That's for sure it is. But what about the fact that ESN might be available next year or the year after? Did that affect the dynamic? Is longer term? That is its. So in those of the judgment to 4.5 and 126 decision. So it is hard. So if I could ask just to put to one side the judgment for and go back to see what the CMA tariffs which the upon which the tribunal page 3 of the and you see paragraph 4.117 on our reviews, it appears had no violence in the 2016 here just on 2016. No violence to consent to the Airwave and then it gives reason the negotiation perspective of competitive market. And then 0.18 the whole able in 20 to Airwave Solutions. And that reference to static in 2016 ESN wasn't couldn't switch ESN even if the contract had page 305 we see finding 4.1 at the time of these 2016 anticipated that ESN Airwave. So the CMA is finding that the Home Office the ESN testing is not over about. In fact, a substitute Airwave will be ready, and that's what this in 2016. Again, that must have affected 2016, and we see it 4.7 it's on 306 that did emerge from the 2016 was ESN was ready or shortly thereafter. Could be an orderly skipping if terms of continued operation were needed. They would further negotiation depend on the strength of bargaining. That's it. So we go back to see.
Can I just ask the decision 4.11 to part 3D? 6D doesn't seem parts to it.
You've got me there. I didn't see any either. Mr. Holmes will help due course it may be a mistake. I'm afraid I listed why there are no parts. I agree, it seems Appendix D there are no parts.
If I can assist, I think it's to Appendix E does have a part 3, an error, a type.
For that. So starts on page 6.
I'll take instructions.
Yeah.
584 of the bundle, 1 number.
My lord, the Appendix D in 7.9, lots are shown.
Well, it is back to reference to appendix. Yeah. The topic. It's the section 584.
Proposing to go. Appendix E contains the minute negotiations. I'm not going to that for precisely the reason my lords earlier take you to the parties. If one of do a bit of reply. The point here is that 2018 the party said was, and so we said about that in paragraph. So paragraph judgments at page 1. And my again, although the Chancellor said, well, to constraint, we see competition references to these are all references. The lack because they could switch on then. That's not right. Competition is the key. An obvious anyway. It was incumbent upon to do that exercise before. And the judgment here.
You can put this point to alternative approaches, because it's so obvious the CAA must there is that the next box down something which they did consider consideration even to, but then they deal with it.
Yeah, you can put that. But the point here is that the CMA what the CMA say, and I'm taking you to the decision. You can read this so include law competition. We're using shorthand. Discriminatory is engaging in semantics. When we talk about constraints, that is both. They can't say they say in the decision leave that static. That's why I need to show you the relevant passage.
I'm sorry, I think there's something which I'm not appreciating. The dynamic competition in practical terms, Council offered or would offer the contract was approved. Is that the full extent of the competition we're looking at?
No, Lord. This is an exercise I didn't undertake to have. Is in view of proximity of ESN, to what extent that create negotiations with office in 2018 in particular. That would be among reflected in discounts, but it might also influence other aspects of the constraint could take other ways. If not pressed as in view of the of ESN. That's
in which terms we've seen was a decision to prolong the agreement
Yes.
evidence that there was dynamic competition in relation to any aspect of the market?
Lord, because that exercise taken.
But in terms of the evidence, that
All I is to my submission. That's the
okay.
of dynamic competition in the real world. Motorola's part on the Home Office, and this Home Office, their position would be to what extent was the proxy ESN affecting your negotiating position, but more evidence than that to put. I think even if I did review it as a merit of the decision itself, there was an obvious which wasn't expressed. So now we look at paragraph 18, judgment, and we look again at the assessment of the firm dynamic, and tribunal find in the negotiations 21 ESN was ready to and there were ones, but they were on the existing terms of the agreement, and finds the Home Office about a third of the way lacked a team negotiation you might expect to have in a well-functioning market. Given is the Home Office provision of the service ESN is ready to. Motorola, again, that's certainly the Home Office bearing in mind the proxy. Where is the analysis of impact? Proximity of the ESN. The focus is on who owns the network, yes, belong to Motorola, made to the decision, but there is no in this paragraph of whether dynamic longer term strained in the 2018. There's simply a that constraints and they were not sufficient. So the decision for 50, which is what the judge, and that's on page 1-2 of the decision. Two, 4.1, and he is looking at on the negotiations in 20. And my point is that what we see, it's about there's no ability to immediately to. So they say what that the Home Office had options Airwave, and there's no technology currently available to Airwave. Airwave is no direct competitors. Further negotiation, Airwave do not currently have an alternative. At page 321, paragraph 4 and 7. Just above it, it's 3 factors that in our view demonstrate the Home Office had continued reliance on Air and on what the position of the team. That's what's material because that time that the price 177. First of these parties were negotiating the operation of the Airwave network and the price because EA was not ready at the time, not ready. The reference and is still a decision is to the dynamic in 2018. Their finding is that it was not ready the Airwave network.
It reflects the tape in the Motorola.
Indeed. Then 1 and 8. office had to have access to work, line, each alternative network. There's no time to which the Home Office, and that again, clear as anything. Competition, that is the ability to switch of whether influence the negotiating the prospect will be available in a year. When there are tensions, that influence the bar, to what extent was that constraint?
Interrupting you, you gave us your as an evidence of competition, how competition operates.
Yes.
It was about the extension of.
Yes. May I interrupt you? It wasn't how competition could operate, it was operating. The prospect of the, albeit uncertain,
There was a about something.
and it was
yes
on the offered.
The short, that's what's reflected in 7.7.
Straight or pressure.
But talk about these paragraphs 4177. The only reference, the reason why the proper constraint is because not ready. You can't read that to say not ready immediately and at its time so as to have any dynamics between the parties. There's no analysis. Separate question of line, and that's important. There is a real two types of competition, and we know own analysis to say when the CMA 4.177 there's no real constraint on because he wasn't ready to replace the red, so the proximity of SM was sufficiently uncertain and distant to have on the negotiating dynamic when they negotiate extension that could overlap with the time GSN might have. Read a CMA statute is doing violence to the language. The CMA focused exclusively on competition, didn't address the obvious criticism whether prospect of the exercised constraint or any degree was available. Is a major failing. It cried out for an outcome, and that, my lords, is round one. That's it. I hope I haven't strayed into question. That's the error. It's here, we say. Although which is lengthy, but that's if the term dynamic competition section 4, we would see it. This relies on the fact that it's an decision with multiple appendices. Point against it, it means that there's no excuse leaving out and an critical. Ground two. Challenge the CMA's analysis. Justice Green asked permission to appeal concern. A growing number of appeals and disagreements dressed up as of law. And reassure my lord that nationality standard well in higher. I'm sorry, Mr. Christ. Not granted permission to.
We understand. We've invited you fully, and we will do things.
Back to earth, Mr. Locke, first time. Permission, but we the court on this ground. I can guess any regular assessment based on a manifest serious gap in the logic of the CMA.
Yep.
Could I ask the to 63. As page 2, the profitability, paragraph 6.1 set the scene by the CMA exercise. Evidence of market outcome, and particularly the profitability of Airwave, was evaluating outcomes of the competitive profitability. Skipping helps the CMA whether competition issues, and if so, the extent customers may be harmed. So this profitability is being undertaken to see if a problem. It's important an assumption is a problem. Page 4. The profitability analysis for the assessment of two things. Mercifully, to get into my basic one, a truncated internal return and a net present PV of profits that but to do the assessment internal return and the NPV to assess the assets, and we see 6.10 when we determine the internal return and by using flows and outflows related to operating activities and the value of assets at the beginning and end periods. So the assets as at the end of the period. Then does CMA propose to value them? That we go to 385. Page 6.6. Page 385, paragraph 4. First of all, the assets are, to remind ourselves what the assets are: infrastructure, transmission network, regional switches, 3,000 radio transmission stations, Tetra radio, particular standard emergency radio communication, different from commercial mobile network used to. Various network management, control systems, technologies. Valuation of such assets is critical to the calculation of profits in this case. For this purpose, assets should be recognized their value to the at the start and of any assessment period. And figure out how the value to the business is established. Implications or caveats here produced on as to how TB is established.
Change that methodology.
No, for we say the total return on this table, the methodology itself is. Now, the tribunal, CA explained, taken this 6.1 into principles for reporting. That document, unfortunately, regrettably, didn't make its way to bundles anytime now because it isn't otherwise the decision. There are other documents that in the course of my submission to the very back. The last is the was a financial report, and this is the document to the. If you go to the document, you'll see figure 6.1, 6.8. In the 6.7, if you skip to paragraph 6.7 paragraphs, as to value to the the in most cases as the asset to profitable use, its most profitable use will exceed the cost. In such circumstances, skipping the value of the asset will be replacement cost. So that tells you what replacement is, and the replacement cost of building a new airwave network. Before the CMA argued that this was the value. The CMA disagreed. I'm not at that point. I'm focused on the approach that they did adopt. So B, an asset will not be if the cost of its recoverable amount. If you look at the picture, you see that cost, the choice between a recoverable amount. Little Roman 2 this is the thing the CMA refers to. When the use of an asset is finished by continuing to its recoverable amount will be the present value of future cash flow obtainable, obviated assets continue to use ultimate disposal, net of any expense to be incurred. In other words, its value in use is the measure that the in this case it didn't, although it's using the value in use, it didn't calculate by reference cash flows from airwave assets. As you'll see, the CMA calculated in use by imagining airwave assets actually used at all to provide communication emergency services. That's why we say irrationality. Now, I'll show you PFI agreements say about asset transfer because it made a provision for asset transfer. Contemplated. There could be assets to the Home Office. The court a clip of documents that I had handed. First section, first part of that is the extract sent to you, and a set of extracts that appellants sent to you, and now they're treated as confidential. Read them out loud.
Green is impossible. Completely to read torch.
Well, that's all decision. Far too late in the day, because especially is a major
Well, I
problem.
did use the mobile phone to read stuff in green.
That's how it's better than mine. So that may be the reason why I'm not.
Could just take the colour of the computer.
Anyway, back to the and asset transfer dealt with. It's the very bottom page of the extract that we.
Consequences of services
Yes.
transfer.
Yes, indeed. And much that more extracts, supplemental bundle, asking to I'm making a very basic, the provision that's paragraph 8 over the provides end to the termination of agreement. See the Home Office in the following provisions to 10.1 option the contractor shall be or he shall purchase transferable for the price referred below. Page, the last paragraph for Schedule 18, paragraph 11. If the authority such option, the authority third party shall pay the contractor fair market of such assets as are transferred. If they not be agreed, resolution procedure routine involves reference to arable assets themselves and on the page arable assets are defined in Schedule 1 section. No suggestion in the decision that the fair for a free 2019 that the assets are zero value transferred to the Home Office was a fee of ABC. No such finding. No, sorry. There's no finding decision. He does not provide for the transfer of the zero cost in 20. There's no decision failure in the PFI causing an AEC adverse effect on competition. Under say
They want to transfer the Home Office would own them, would they?
allow them to be transferred to a third party. The Home Office was guaranteed to get 2019. It would have could say, we're going to invite just assets and you will own them.
Significance of that for the decision, they then finding about the actionability during the extension.
To value the asset, valuing the assets, they constructed based on a well-functioning. They say in a well-functioning, these assets for the Home Office. The Home Office would have had the option in 2019, giving them a value to Airwave. But where does that come from? The agreement itself makes provision express for a fair assessment. One thing if the CMA says this procurement act is flawed, efficient competition, and the failure for a or failure to allow the assets in 2019, that was a feature that we see. It itself, despite the exercise, is tainted because this feature caused an AEC. One thing, but that's not what they do. And what they have done is their counterfactual in unreal scenarios, and that's what I need to do with the decision itself. So back to the decision. All right, let's see what's page 399. So they may value based on their value in and where they got how they have 6.99.99. Conclusions, valuation of the we've considered potential valuation approach that we saw in that skip costs because they haven't gone from that over net realizable value. C, we consider that the value in assets period in a well market be zero. Right away, one sees they have departed the very guidance that they figure 6.61, which says that value in use, the value to the assets that you get from running the contract, it's not, it should be zero. Zero for those assets required to operate the network in the original PFI. However, we consider that, skipping down to the investments made in the network 2019, they should be recognized. And over, they give value investments made after 2019. So 2019, the assets used up to that point, zero value, because that's higher value that they estimate to, that's the figure they use to value the assets. So how do we get to that conclusion? High value in use would be zero, and page 395, 90. Our assessment in a well-functioning, in the situation where is provided with the revenues, the opportunity to recoup outlay customers to ensure protection, the pricing of these in the event of requirement beyond the envisaged. More specifically, we would expect pricing during such an extent to be constrained, which broadly only for the increment required to sufficient operating and so forth, taking into account the consumed by the supplier over the extension. 571. How they say assets should have zero value the period. And one, this constraint could either by contract in the PFI agreement, by among several LMR networks which were already in the market. They're positive for their counterfactual. The idea that there will be among several network suppliers already in the market, already incur the constructing a network. Now, which had already sunk the cost to develop and provide competitive, we say completely unreal of the CMA's acknowledgement. This was a bespoke work, procured for a single, and we get that if you go to page 394. Page 394, para 6, the CMA's own decision. 687, characteristics of large sunk costs with the development of such an network are such that there is a single supplier and one or more, a small number of products together. We will see products being developed speculatively, rather purchaser commission, so the purchaser commission supplier operates the network. You have a specific procurement a single by a single supplier of LMR suppliers. So back to analysis in paragraph 9.1. After 7.1, we see result again. Actual how the contract allowing the Home Office to take the thing at the end. Team achieved by different, including, for example, the contract effectively for the assets in the period. So if you have a transfer retendering of the provisions using the already for
I don't at the moment see Motorola as recorded paragraph 6 and the market value. Now seem to put it okay.
we made this fair market value, and I'm able to get detail for many of them. We certainly made the point to the CMA and the that the agreement and the PFI for the proper.
Yeah, that's what it did. Doesn't in front of it, as far as the CMA was, you were arguing that the fair procurement process and the contract contains an option to market value, and that's the value which may adopt, which would be net real value of paragraph 6.
Understand. As I said before, most that the proper approach to asset value was in that table. We said what the assets are true, it should be modern equivalent assets.
Saying, well, somebody else entire network. That's why when you do what the CMA did, case is it's that Motorola the value of them, not the transferable.
Indeed, it's true. They had to refute the point on modern equivalent assets. They still have a rational valuing the assets for the stability assessment. Using that to determine if there was a problem in the first place. And so in the case where the CMA, the only reason we did this was because we were a different case from, of course, except that their emphasis on by the case they have to Motorola. The flaw is in the decision, is what was obvious to them, and it's obvious that it had to be addressed by them, which if they're going to treat assets as worth, what basis for doing that? And saying that this is something that the by agreement said, and where is the feature in the PF causes an competition? The findings support that conclusion. So we see what they did in paragraph 6. The key from the buyout report, again, we were able to say this should inform the followers, and they didn't. Seeking to now before it's in my written the point I'm making now. This is the more basic one. 6.96. They said be valued the will be traded in the existence of market. They said in value you have to take away power. That would be best. Fair market value of the asset in their as at the end of 29. But then this contract with the homeowner, i.e. value in alternative use. What the CMA found were Home Office, particularly for the purposes of this network. They were employed some costs exclusively for the purpose of this secured network. If they are treated as having an alternative use, this is scrap. If you're forced to say value them as if they have use in such there's no possibility of use, that is a scrap value. And I understand the idea of removing market power they've identified to value the assets. That could one the submission I'm making all morning. Move Airwave's market power. You could ESN was the CMA's own announcement at the then coming on stream, right? That would constrain any market power, the CMA's own analysis. And that could be used then, the value of the assets would be. In those circumstances, they were to be taken to the party. What would you expect to be if you could transfer these assets for the ESN is, but instead, the Home Office, sorry, the CMA treat them as having value they would have alternative use and to scrap, and that is irrational. That to any rational basis for assets. We say really this approach to reduce the ability figure which shows the problem. And the problem for the PFI agreement was produced functioning market. All the CMA found its terms lack, but as I've said, itself, this part to provide transfers the assets free in 2019 and to involve C. Remind the court summary in page 1993 of the CMA decision. Paragraph 14 to 15. I should, my lords, but if you could just read 15 on page.
That's just down from the decision. They adopted a passage report, said that on profitability there would be exceptions. The buyout report you took a that they would be traded of the contract. The buyout report assumed an alternative.
Yes.
On the facts of the case, on the ground this was an alternative use. Then you say the fact that you have your costs over the entire contract doesn't mean to say the value. There had been an alternative use. Something, but it might have been above. Is that what it comes down to? No, don't take properly there. But properly simplified. What the VA is.
That is,
except that the amortization,
yes,
of the contract. Your point isn't necessarily that the price is zero. If there had been an someone might have a discounted price.
if is to reference to its sale alternative in a market where yes. According to CMA's own value and assets, they adopted the value approach. Starting point is value you get from under the contract question. That starting point, which the although they made radically to secure their objective, and to the extent they were
just a tricky because it's not. This is in use of extension in contract under use because of the extension. Different, as they say, a change of circumstance.
Indeed, but if is that an extension? Again, we come back to it was always the possibility of extension. It was that the replacement would not be ready when Airwave contract expired. All matters were capable of negotiation in the PFI agreement was made.
But they weren't.
And the question is it a competition problem? Competition problem. PFI agreement was made that caused effect, and CMA has there isn't one procurement exercise. The parties were aware of the risks before provision in respect of them. A submission of the decision protects the decision itself. To give an example, this may be confidential. There's a rate of return expecting the agreement. The network were more expensive than anticipated. Return may not have been expecting of the contract. The details are in similarly that the network wouldn't be ready by agreement. The Home Office could have addressed it. On the contrary, they did make provision for assets, but at a assessed according to a process. Taking that last
transfer of assets covered all the nation, including the course of the contract.
yes.
It wasn't just expiry.
No, of course.
According to the break.
But my point is the one it was the one at the beginning of the, which is that look at this and you see in the context that was made. If the CMA wants to find PFI agreements to provide the assets that was the they should have said instead.
Paragraph 6.6. See a effect. Transfer provision refers to fair value of the asset, and then the remaining is what they believe its value to be.
Value, tying it to the
Agreement provided.
not on the unilateral of the CMA. There's a process for market value. First point. My second,
They can't be bound by.
but if they're going to, they have to explain why feature which gives rise, which justifies it being ignored. And the second part that fair value, a reference to an impartial use. That's the real paragraph. They say as if it's not being used for the purpose for which it was constructed, any possible use. There's no suggestion in this decision what alternative use could be scrap. So as Mr. Tucker says, to arbitration under the agreement, the arbitrator would, this is all going to be scrapped. Approach the arbitrator to valuation. Because the arbitrator would take into account, the arbitrator would take into account
The only
the fact
formulation, market price, fair market value. So, market value, fair.
and here I am, and this might depend on spot assessing what is fair. Begin with the PFI agreement. He would acknowledge, or she would acknowledge that of the agreement, motor assets at the end of the contract. He would acknowledge that the contract requires extension. The Home Office requires Motorola's assets, and he would how much they how much value of those assets in the assets. In circumstances where this is a value sense that even though the amortizes, they plainly have a value used, they're extremely extensive. So how should Motorola be? It's highly unlikely, and the CMA has never suggested that if it was an arbitration, the arbitrator would say 0 by anyone. Contract, these are zero value.
Contracted to be 20 with 15 at the outset. Any different?
I'm actually not going to go beyond that question. That depends on a number of a
You'd
large
still-
number.
The principle is you amortize costs
Yes.
and get a RR over the period.
Yes.
The costs being the same. They may be different because Motorola compensated for improvement to the network. Costs would have been the same period. It would have been different improvement costs. If the model would have been
2 points. Is it a contract? It's not just about very, very serious level throughout the to these various, the police, fire. It is a service contract. It's a judgment, detailed service provision, very complex way throughout even 19. Secondly, marking provisions in the which are designed to assess from time whether the agreement is still providing. And there are provisions which we would expect in a PFI to ensure the long-term contract. That question, whether it's an increased rate of or other things have happened, baked into the provisions. Now, the CMA, well, they didn't work very well, but well, certainly
challenging the period, it assumes that it is competitive.
Yeah.
Not is neither here nor there. The premise is competitive. The period that was amortization period.
yes,
And then
yes, which is why in that summary, what to expect from
well-functioning
Mr.
market.
But after 2019, things if they're not going to by agreement, as I've been describing, they can't actual that just ignores it. Especially one based on situation numerous LMR networks on costs competing, as you saw it in. Reminds me to the point that 2019 is for the Motorola to contest. This is not required after 2019.
But those were compensated.
CMA made provision for 2019, yes, and the 26 is roughly the same old as 2018. As to whether there was something so fundamentally PFI agreement that it should be treated with suspicion or creating an to look at the CMA of it. And we see that in the appendix B, in the decision, page 485. 485. The tab 9. Home Office responsibility in 8, information technology, a public body established procurement management, these kinds of procurements. Page 7 now, 23, and I anticipate a point that in the skeleton, how problems with the procurement influence the tribunal and the that isn't, even if there were problems, go to the points we've been discussing, just to show you the background that inherently problematic, which is presumably why the findings it did about 22 each learned that the absence of conflict would make it demonstrate. This is in the tendering exercise, including one bidder being one. The authority was concerned that the absence of competition would to demonstrate the offer from the remaining represented value from it consults 3 Home Office procurement, Her Majesty's Treasury, then PFI, Association of Chief. The project might be BT that was bidding, proposed that any value for money should be by the use of a should model. And we see that addressed page 4. This should cost more, almost like a quantity surveyor. Work on that in 1990, refined it until should cost model calculated an of figure which isn't. Oh, you see, Peter used the cost model to challenge between its and 2 is now BT, the bidder. And O2 told the National Audit Office these discussions reduction in the cost stations. And 2 before this, 2001 month was awarded the Treasury. PA examined the procurement network urging recommendation from a Cabinet Office major government IT was concerned with for money. PA consulting management delivered issues regarding it made recommendation changes and Peter responded it would implement including improvement the management of identified risks. So, my friends can the detail and there's a great analysis of the procurement, but you will find to suggest that the competition procurement amounting to an nature. Go please further on 578.
Express findings that paragraph 15 and summary.
Yes, indeed. 578. Appendix E4, the analyzing the ultimate contract, the exit and asset didn't provide transfer of air assets to the home cost. The end of the PFI, that was a departure from general further to guidance. The basis on which the value was calculated is in the agreement. That creates uncertainty, potential for just had the Home Office to purchase assets. Makes the decision. Looking at an AEC fund, one doesn't find it. this, a finding that the and to be clear, most of the CMA is could in 2000 in analysing the PFI agreement could have said accepts that that is what it when it was negotiated in 2000. So these well-market counterfactual that relate to hypothetical or PFI that might have been in 2000 of the terms agreed.
The point can show that there was an effect on competition. The CMA said that they expect a functioning market and the group return see the actual agreement contains terms EF we wouldn't have expected in a functioning market, therefore to conclude that the contract actually was not the functioning market.
That's precisely the exercise they don't these power under section powerful it gives this extraordinary power to agreements to remove from attracting party of to which the parties have agreed. And so these question Parliament made to be very clear as to the issues which create effect on competition, trigger the power to rewrite contract parties of the otherwise be entitled.
And you accept that they can retrospectively look at a contract that's been negotiated, compare that with expected in a market, reach a conclusion of competitiveness of the actual market contract.
Of course, and it's open to them to PI agreement. The fact that they applied for a transfer of assets in 2019, you're creating an A. They would then have to, because that would be a surprise in an otherwise lawful. They'd have to, notwithstanding lawful procurement flawed. On the positive finding in the that the PFI agreement is subject to some from a well-founded.
Why? You've got paragraph, I think is which says paragraph 6 says that what happens is a material change. So you're in analysis. Do you not accept the position from as usual in a new situation? Do you challenge the analysis?
We did say we maintain it's artificial to split the period, but even if I'm wrong, to the extent they're constructing a that could be in 2000, they have to what is anti with the PFI agreement to say not what we'd expect, show the features that we see, and if the feature we're focusing on is the failure to free transfer, and that has
as a counterfactual, which they're analysing per the start of the contract, goes to the extension.
The counterfactual creating, even though focusing on what happened in 2019, the counterfactual, you saw it yourself, might say the contract could have provided for that. That's the 2000 they're talking about. Factual is contract PFI agreement provided transfer of assets. So they are focusing on their own approach.
What they did could you start with the premise that in 2019, absolutely fine. There's no need.
Yes,
it's a you would find in a functioning market. You then say of that date as amortized earned an IR is proper. So don't you say we're now valuing those assets the supply customer as of 2019?
yes, but if in doing that, if you, because that's now depends on what a well-functioning market will produce. Say a well-functioning market, that outcome. But what they have is that constructing a counterfactual exercise, the PFI agreement is from a well-functioning market, and it tells you. So, if what a well-functioning market, they have to address the agreement comes from a well-functioning market. The opposite, and they that in their asset.
The well-functioning agreement tells of the end of the
Yes.
supplier will have II. To the extent that we get in 2019, that's part of the new starting point.
My lord, no. The PI agreement says more. In fact, the PFI doesn't say you amortized 19. The PFI at the end of 2019, Motorola owns the asset, and they have by reference their continued. That's the agreement.
Reference by reference.
Indeed, is bearing in mind undoubted contractual to be remunerated continue to be theirs. What is the fair value? Decide. CMA's approach. The CMA use scrapyard, and these are treated as being zero to Motorola, notwithstanding what the well-functioning market. One can see where they're trying to get, but the important findings there aren't in the. Stockers tells me the asset transfer is governed the end of the originally, and so must have been. I mean, what the parties were present, they were dealing in 2019.
Because there's transfer provision which applies at the time.
So that's really it, my lord. That's the case. We have that sort of logical gap to the territory of irrationality. We're not nitpicking. This is a huge flaw in profitability analysis. CMA we rely upon in an AEC. It's I was check to make sure I've not missed anything. Finished rather early. Unless I give any further assistance to you. Those are my submissions.
Thank you very much, Mr.
So good afternoon, my lords. If it please the court to proceed as follows, giving you in and out on each of the grounds, I'll then turn and the decision. As we see it, the case lies analysis, findings contained in the decision to provide an answer to the grounds of appeal. Proposed to address on the law. It seems to be it's common ground. The only points we would have for your note in paragraphs 30 and 34 of the judgment, namely that one should read the judgment that were but as a whole avoid passages in
including the details.
Yeah, in
Set out a lot of working out.
yes,
Like its profitability analysis.
indeed, my lord, and the profitability analysis we rely on margin of improvement in of technical profitability analysis is a paradigmatic in my submission area that requires complex assessment and the given an appropriate time to reflect. So, as regards further submission, so far as there in the division, I shall grade 1, and I know we'll deal with it in relation to 2. So in our case is this. Ground 1, foundation of inconsistency, market definition in section 2, and of assessment in section 4. In section 3, says the CMA recognised existence of dynamic competition between Airwave and but in section 4, it is said that may consider competition a mission, the conclusion that monopoly power, and that's said to be a account of a relevant consideration. So, Justice Lewison's help. A consideration arises because it's one by it's as relevant. I think this is put. If I understand rightly.
I thought it's so obvious. Decision maker must.
Yes, my lord. Now, the same argument was advanced as first ground below. The tribunal was right in the reasons it gave. The ground is it does not reflect the CMA in either section 3 or 4. In section 3, the market definition found only the potential for competitive interaction between ESL and the Airwave. The prospect of ESL could, in principle, least incentives, move its offering in order to retain in the longer run. There was, however, no that there was any negative constraint on the wave. Reason of forthcoming, still less finding that constraint effective in removing market power and prices as one would expect in a functioning market. A noted definition does not the outcome of competitor assessment. Section 4, assessment, examine what extent Airwave was constrained to the original term agreement. It looked at the state of competition, and in that connection, it looked at the negotiations Motorola and Home Office outside the tendering process to see whether the ongoing competitive constraints deposited in sector that remove market power. As my screen observed, insofar canvassed, insofar constraints existed, it would be in relations between Motorola and the Home Office. Would expect to see work. The price of the interplay of relations. The CMA therefore detail the internal document, the agreements that were reached, as well as the return property for Motorola. And based on this, the CMA that Motorola effectively trained killer pricing. So we say there is no tendency to take account of material consideration. The ground alleges that they aired the network assets that were developed and paid for during the original period. Specific Motorola is that the CMA defined them separate values in respect of their use, which is said by me to be inconsistent with the CMA elsewhere in the fact that the agreement provided for assets transferred at the agreed fair market value. Second, that the PFI resulted from the tendering process that might be expected to provide effective competition, and that the absence of a finding, the asset transfer constituted AEC. Again, all advanced below, the tribunal was for the reasons it gave. Is in reasoning. They found that Airwave had already had the opportunity to recover the capital of building over the term of the agreement, 2000 to 20. Moreover, Airwave had in fact needed their costs during the period and had 11% return on their investments. Yes,
To say,
yes. No, yeah. My lord, we were concerned it might be confidential. Be corrected if I'm wrong. It's not a confidential. The contract was both to construct the asset and to operate. To allow Motorola to charge in the period of 2020 as though it was building a new network instead the existing asset would not the price be able to charge uncompetitive. Such prices are above the risks incurred continuing to provide work which had built and paid for. Actual setup with the functioning market, CMA found it would not be able to charge twice this way. It's ongoing,
Which it found to do.
which it was entitled to do, but not the costs of the build already been paid. Be achieved acquiring Motorola for the assets so that the service could be delivered under provisions that were effective. I shall show in the decision that those by agreement are effective for provisions requiring Motorola to lower the after the agreement because then had been recouped. All that was being provided then was on provision, construction element, original contract. Under either side, the price reflect Motorola's costs, ongoing provision, not costs related to the capital costs that had already been. As regards consistencies by Motorola, the CMA were the terms that were affected functioning market, not those in fact that my Lord canvassed with my learned friend. The fact that the PFI agreement dated in 2000 contained terms does not show error of approach. They did not find terms in the original agreement basis with effect. This specific context, the expiring term of the agreement, it found that terms needed to secure effective competition was the alternative use by the CMA that the assets scrapped. That misreading the decision. The alternative was a counterfactual agreement, no contractual commitment, which required payment that reflected costs during the initial. The assets used to other as a result of tendering provisions that require to be reduced by a genuine cost provision.
Well, your point, one way or another, and not entitled to take over.
Yes, that's quite.
That's it is. This the CMA for that result, but the correctness of that result, say, is unimpeachable.
Yes. So we say no between the stability analysis and the fact. Perhaps say there's a question that the CMA's the features giving rise to the didn't cover this. Well, as to that, features included the effective asset somehow competitive. We say that it was covered. In any event, this is a example of the point of the decision that it were a statute, but as a whole and in. Turning to the
Do you want to?
of course,
It's slow. I think it's pretty. So if we
very good.
place it back.
Court rises.